within 3 months, and that would be an ad hoc committee. And if you noticed what I did there is I gave it a very, very narrowly defined scope. The ad hoc committee has to also report back to the board with its recommendations. It can't do anything else. There's also like number requirements. What's your remind me your board number?
There's Marcus right there.
21 board members.
Okay, so you're 21. Your quorum is 11, I assume.
Correct.
Okay, I'm sorry, and you can set your quorum whatever you want, but you've chosen to set your quorum at 11. Does your board take official action by a majority of those board members present at a meeting?
No.
No. Yes.
Yes. Well, by a majority of those present and voting, assuming we have a quorum.
Okay, after you have a quorum. So a majority of 11 is 6, okay? So this is going to be your majority number right here. Everybody see that? Because you have the possibility that as few as 6 people could take action on behalf of your board, all right? So this also sets the number for your ad hoc committees. It can only be 5 or less. 5 or less board members on your ad hoc committee. They have to take up those issues, limited jurisdiction, limited time frame. They can only report back to the board with its recommendation. So if you fit those parameters, that's the only thing under the Brown Act that's allowed as an ad hoc committee. If you fall outside those parameters, you have to notice that meeting as a standing committee. You could call it ad hoc committee, call it blue, call it whatever you want. But whenever I'm using the term ad hoc committee, I'm talking about a very specific requirement. So remember, it's temporary, it comes back to the board, it's the 5 or less here, all right? It's limited in time, duration, and scope. So that's kind of the criteria that it has to fit in. What happens if you name a member of the public to your ad hoc committee? Anybody have thoughts?
Then it becomes a public committee.
Yeah, correct. So you have to follow those requirements.
But that's not really the question that has arisen here about committees.
Okay, so
the question,
I walked in a little late, but I wanted to correct a statement about ad hocs.
Right. Here's the question. We have a number of what we define as standing committees, all right? Most of them do not meet every month. There's no need to. As Eric explained,
when you have business.
When you have a business as a bylaws committee, then we meet as a bylaws committee.
Correct.
Same for beautification, same for public health. So is there a requirement, other than the posting requirement, that standing committees meet at any frequency?
No.
I'm talking about Brown Act, not done.
No.
Please repeat that question.
Is there a requirement under the Brown Act that standing committees meet regularly? No. Because the Act presumes that whenever you do have that meeting and you notice it with the 72-hour requirement, that's deemed a regular meeting of the standing committee. So you don't have to have a fixed schedule for your committees. You do have to have one for the board. You have to have the fixed schedule for your regular board meetings.
So we're in compliance with that. That's a statement. I'll make it clear.
Yeah, no, of course, yeah.
Everyone in the room, we're in compliance.
So, I just wanted to also say hi, everybody. I came in a little bit late, and so I'm going to sit here. After Lois is finished with her presentation, we're going to do some exercises with the board so that we can go through a couple of scenarios and help you guys out. I don't know if you have questions for me or for Lois, or
I do. I want to get a clarification because Lois had said if we were at another function and there were a quorum of people, meaning the 11. That those 11 people couldn't get together and discuss items having to do with neighborhood council. You brought that down to 6. Yeah, so what is the number of board members that that can be at a function, discuss things amongst themselves? I'll
answer your question on a legal basis, but I'm going to make a recommendation to your board based on the situation that you're encountering at the current time. And that is that none of you should discuss any business with each other when you're at another function, okay? You're under careful scrutiny at this point in time, and you should each just kind of try to avoid any discussions with other board members about any issues involving the board. Now in answering your question, okay, if you go to a party all of you can go to a party. You can all go to a party, you can all sit there and talk about the weather and whatever else you'd like, okay? Not an issue, not a problem at all. What you do have is you start having this concern, and then I'm gonna make it both black, gray, and and confusing, all right, for everybody, all right, and then you'll understand why we give the advice that we do, all right. Here we knew that as few as 6 people could have could potentially have an issue with having a meeting. Your board could decide something. You all say, we're going to put trees on that median, and 6 of you have had that discussion. You know, you've gone to city council meeting. The 6 of you have had that discussion there. So you've already kind of formed a concurrence. You see that there's a concurrence among 6. You've all agreed to kind of do it. So you have an issue then, once you have those 6 people, that could potentially result in a violation of the Brown Act. I'm not saying it is yet, because you don't know what happens until after the fact. Let's say at the next meeting that you come to, you have that agendized on the agenda for discussion and action regarding, you know, the trees in the median. Okay, those same 6 people who showed up, right? And you have 11 more showed up. So now you have
6 and 11, or you have 11?
You have 11. You have
11 total.
You have 11 show up.
11 total.
11 show up, and the same 6 that were at the other meeting, and they discussed it among themselves, right? Now they show up at that meeting. Now, do you see what's kind of happened? They have, in a sense, come to a decision outside the board meeting. So under that factual scenario, you have a violation of the Brown Act, which is why I say, if 5 of you can agree to do whatever you want, you can have a blood oath, you will never ever have a Brown Act violation if 5 of you agree to something. You could form a faction, you could form a clique, you can do whatever you want. You will never have a Brown Act violation as long as you only have those 5 people. Those 5 people could talk and decide whatever you want to do all day long, okay? Now, you're never going to have one because you can't even meet the threshold. Once you meet that threshold, all right, now we know between 6 and 10 is our gray area. We have the potential for a Brown Act violation, but because I can't predict the future, I can't tell you, well, who is going to show up then at that next meeting and who's going to form a majority. So if you have those people forming a majority at a meeting where it's decided, then you have the Brown Act violation. If you kept it under 6, you can never have one. Above 11, you know you did it again.
So just as a kind of a defensive measure, and I'm talking legally here, let's say 8 people get together, they discuss an item having to do with the neighborhood council, they go, okay, this is great, we all agree on this. You show up at a meeting and there's 12 people total there, so you realize, wow, the 8 of us that discussed this actually have a majority. We're going to defer, we're going to postpone this item on the agenda because there's a possible Brown Act violation. Wait until we have a greater number of the board here such that those 8 people do not make a majority. Is that,
this is not the recommendation.
I understand it's not the recommendation, but is that, if we got ourselves in that position, would that be the appropriate action to take?
My better recommendation to you is never be above 5, okay? Now you've gone into a situation where those 8, you are engaging in a serial communication with 8. It's just a matter of risk when you're going to get caught, okay? That's the problem with the hypothetical you're giving me. If those 8 are there at the meeting, then, you know, who knows, because there's all kinds of other types of issues that might lead to a concurrence. Maybe one of the 8 already slips it out at the meeting and says something that they've already kind of all discussed. You know, you're compounding a problem by not trying to be just keep it easy.
Is our appropriate response then to not take the issue up?
Yes.
Okay.
Yes.
So I'll ask this a little differently.
Yes. Your appropriate response is the appropriate response is 8 of you shouldn't be talking about anything outside the public meeting. Okay. If you did that, then and you find that situation has occurred, then the 8 of you shouldn't be participating in that meeting when it moves forward.
Okay. You should recuse at that point.
Yes. Oh. Yeah. I would recommend that you recuse at that point in time. You're putting yourself at risk. You're putting your fellow board members at risk.
What's the penalty
for serial communication?
No, for a Brown Act violation. I read the statute.
Well, I think as Lois pointed out earlier, it can have both civil and criminal penalties. So it can actually be a crime. So it can be prosecuted, it can go on your record as a crime.
Is it a misdemeanor or felony?
It's a, yeah.
Which one?
Did you hear misdemeanor?
Misdemeanor.
Oh,
But you don't want a misdemeanor on your record. Nonetheless, it has a number of impacts. It also has some other punishments that come along with it, including a bar from holding any office. So you couldn't run for office in the state of California.
It's not necessarily a punishment.
Depends on your point of view.
Really, the violation occurs when the vote at the general board meeting happens. Not prior to that, not any of the communication, it's really once, so
Okay,
as a
but-
defense,
but-
if you recuse yourself.
But knowing,
okay.
okay, but just.
I just wanted to be clear. that's all.
You are correct, but this is the problem with human nature, okay? We can't keep our mouths closed. I mean, we really can't. If I've started talking, we can't. If I've started talking with one right before the meeting, I'm gonna mention it to somebody who's not in the six. And you slowly get to a situation where you've escalated and now you've created a problem for yourself. So the scrutiny that you're under now, just save it for your board meetings. You know, save it. Let's be the ideal neighborhood council at this for going forward for a while. You know, hey, that's board business. Let's discuss that at the public meeting.
Just
you
for a
know.
while. I'm only repeating what our council has said.
Let's do this approach. Let's do this approach until we can say like, wow, you guys are getting an A with Brown Act compliance, and then we'll remind you again. Okay, if you absolutely have to, you can go back to having 5 or less talk about things.
How come the city council gets away with it all the time? They go into closed door meetings all the time.
Because I'm not there, you know.
Why not? You're a lawyer, you're an attorney.
Well, you guys are my, I work with the neighborhood council.
We're all here on our own dime.
But they're spending our dimes.
Well, and remember, there are some. I don't want to. I'm not going to imply that they have done anything inappropriate with the bond. I don't have any information about that.
It's all the time.
But there are things, because of the situation you're in, there are some differences that you may perceive that they've done something inappropriate, but it's not. Like, for example, one of the things that we could do, okay, I could do this, Melvin could do this. We could go to each one of you and talk to you and give you a briefing about an issue. And there's not a problem with that. And so the same thing, but it's because you don't have the staff, so you don't have that kind of flexibility or issues that, yeah, that does facilitate some of the business that's conducted at the city council level. But since you're not in that same situation, you kind of have you're handicapped.
The Brown
in that
Act was
area.
created before the neighborhood council situation. The Brown Act was created for city councils because of the collusions that they were doing in the past and everything.
That's right.
And still, they have these closed door meetings in which the public is not allowed.
But closed doors are allowed.
Some of them are allowed.
No, closed door meetings. There are exceptions for having closed door meetings.
But they're
You
talking
can have-
about public money.
There are some exceptions for going into closed session.
Okay, which ones can we use?
You don't have, you've jumped ahead of the
Next
train.
topic.
Let's go on to other
Yeah.
topics.
I have a
Wasting a lot of
question.
time here.
Yeah.
Let's do that. I'll let Lois
What
wrap up, but I
happens
wanted
if
to
you
say hi.
have 8 people at a meeting and they don't all agree? I mean, you could have 8 people and 3 of them say, I don't agree with you. Then you
But because they talked, remember, it's not just about the vote that they gave, it's about the knowledge that they acquired. The test is a concurrence, and it loosely means anything that contributes to that person's knowledge of the event. It doesn't mean that those 8 decide, yes or no. I mean, 8 of them have engaged
No, I
in.
don't like that at all.
Yeah, but you still had a discussion. Let's say you still had a discussion going on outside the meeting that helped you reach the decision how you're going to vote. So it doesn't matter what your ultimate vote is. It matters that you participated in the discussion.
And you had a meeting, and you didn't post the meeting.
We'll finish and then we'll do exercises.
There's plenty to eat there if you want to bite.
But you got here late, so you're.
Yes.
What if you have a plum meeting It's not a plum, an official plum meeting, it's not agendized, it's not noticed, but the members for Granada Hills South Neighborhood Council Plum meet, and at that meeting, there are also several, and there's 6 committee directors from Granada Hills South Neighborhood Council. Along with that, there's at least 2 directors from Granada Hills North Neighborhood Council. Is that a violation of the Brown Act when they are discussing issues and then voting on it?
Not until voted on.
Well, if you're having a meeting and there is more than the 6 board members there, and they are discussing something that is gonna come before the board,
Right?
then that should be agendized and posted to be in compliance with the Brown Act.
And then if they go ahead and they vote, those individuals, it's a decisive vote, then they're in violation of the Brown Act at that point, correct? At the general meeting.
If the 6 that voted at the plum meeting then go to the general meeting, then that goes back to what
We
Darren
don't
was saying.
have 6 people on any of our committees.
Can I just ask for a correction? I mean, a clarification. You mentioned there were 6 people in the meeting total. 4 is from one neighborhood council and 2 is from another neighborhood council, right?
Yes.
So it's less than 5, so it wouldn't qualify because you're from, even though they're directors, but they're from 2 different neighborhood councils. So you have 4 from one neighborhood council and 2 from another neighborhood council,
6
so that
from
falls
one
under
and
5.
2 from another.
We've never had that.
Yeah.
Well, then you should.
But I'm saying in her scenario, it doesn't apply because you have 4 people from, for example, South neighborhood.
You shouldn't have more than the 6 people from your neighborhood council that are board members at a meeting making decisions or voting on an issue.
We have never had more than 4 board members on a standing committee, and we've always made sure
Well,
that
but
a
it's not-
stakeholder
it's-
was on that committee with us. So, but if it's a meeting is posted, it means that anybody can come to that meeting.
Anybody can come, but
But
if
only
a
the-
board
only-
member,
only
if
those-
another board member comes,
He can't vote.
he cannot discuss, offer any opinions, only
Only the
observe.
stakeholders, only the stakeholders can come and offer their opinions, because,
Yes.
Committee members.
but we often have stakeholders who have an interest in a subject that we may be discussing, and we have always wanted to hear what the stakeholders had to say.
Okay,
So is that unfair?
no.
Okay, then what is the problem?
With having more
The only
than,
people who are voting are those standing committee members who are allowed to vote. That's it. But other people may come in and sit in on the meeting, and they may offer information.
they may not, if they are board members.
No, I'm saying stakeholders.
Okay,
Who
then with the
come in.
stakeholders, you don't have an issue.
Yeah, we don't have an issue with stakeholders.
Okay.
But people may come, if you post a meeting and that meeting is open to everybody to come,
Yes.
we don't bar people from
Right.
coming to that meeting.
Right.
And if they have something pertinent to say on the subject at hand, then what is the problem?
There is no problem.
The only people who get to vote on the issue are those people who are on that standing committee.
But the standing committee is going to make okay, you're right. So there are 6 board members, but only 4.
5, we have never had 6 on
Okay.
any meeting in
Okay.
any standing committee we got.
There's 4 board members.
She's
that
trying
are-
to poison the well by saying 6 and 8 and all this other stuff, which is crap.
Okay.
No.
If you have, 4 board members on the committee, and 2 more board members decide that they want to come to the committee meeting and talk,
No, just sit
they
in.
can't do
They
that.
can't do that.
But 2 stakeholders can come and
They can say
talk.
whatever they want.
Right. Okay. So we're all on the same page.
And that's what I'm saying.
Right.
Let's move on to the next topic.
Well,
Okay.
before we leave this topic, just because I know what Ms. Romney is referencing. So I want to put this and make this very clear.
Well, if we're talking about specific issues that are happening
She
or
is talking
may.
about a specific meeting held last March.
Okay, then that's not something we need to take up tonight. We're trying to get a baseline and move forward so that we don't have any Brown Act violations from this point forward. And it doesn't really, it's not productive to go back in time to look at what may or may not have happened at some point in time. And I'm going to take your question and that's it.
So in a nutshell, if there are 5 or less board members from the neighborhood council at any of the standing committee meetings, then they wouldn't be violating the Brown Act no matter what they did. But if they don't post it, then they can't vote. You know, they can discuss it, they can't vote on it. If it goes back to the general board, it can be a motion made by anybody at the general board, but it's not by the committee because they didn't meet the Brown Act posting. But they still have not violated the Brown Act as long as they have 5 or less board members there at that meeting. They can't possibly have violated the Brown Act.
There's no committee
Well, they have to
nomination.
adjourn the meeting? If there's less than 5, if there's 5 or less people, they actually have to adjourn the meeting?
Was, how many was on the committee? And you're saying
5.
5. And
If
what
there's
is-
5 board members on the committee, and
And they
they
didn't post the meeting?
failed to post the
They
meeting,
adjourned the meeting.
then they have to adjourn the meeting, okay.
For a different reason, because it was.
All right, let's move on, folks.
All right, so when we have our meetings, they have to be open to the public. That means any member of the public, not just your local stakeholders, anybody who wants to come should be permitted to attend. You can't charge fees for people coming to a meeting, and you know, sometimes I see some people laughing, but if you have, you know, sometimes neighborhood councils ask if they can have, if they can participate in a festival or something where all of the board members are there and they're going to be discussing board member stuff, and they charge fees to come inside. You can't do that because it's not open and accessible to the public. So you can't charge fees to come in, and you can't require people to sign in or really to fill out the speaker cards if they don't want to. The purpose of having a speaker card is to sort of control the meeting, the flow of the meeting, and when somebody is going to be up to discuss a particular item. But if somebody doesn't want to fill out the speaker card, you can't make them do it as a condition of speaking their piece about an issue before the board. When you have meetings, the meetings need to be within the area that the neighborhood council has covered. And obviously that would include being in the city of Los Angeles. And you can do teleconference meetings, but there are very strict requirements on doing that. When you have your regular meetings, you have to notice on the agenda the time and the place, and you have to post it 72 hours ahead of the meeting. So you have to list on that agenda all of the items that you're going to discuss or act on, in a way that informs the public what is going to take place. You have to let them understand the general nature of each agenda item, and so that they can make a decision whether or not they want to come to the meeting. You can't make it so general that they don't know what is really going to be covered in a meeting. The Brown Act says that it doesn't have to be really wordy, it doesn't have to exceed 20 words, but you have to provide a reasonably clear understanding of what's going to be considered by the board. If you have a committee that's going to make a recommendation to the board, then the committee should, on that agenda item, provide the backup documents that they're going to be using to base their decisions on. You should somehow put a link on your agenda or attach copies of the reports that the committee is going to use, so that the public knows and is informed about what's going to take place with respect to that agenda item. If it's regarding a specific project, you should identify the project, give the address of the project, or somehow identify it so that the public knows what it is that is going to be discussed. For special meetings, yes?
What exactly constitutes a legal 72-hour posting? This is, I'm from the Plum Committee of the North Neighborhood Council, not the South. But the questions come up whether it's sufficient for us to post in the 5 locations, physical locations in our bylaws, or whether agendas, also committee agendas, also have to be posted on the website. Our bylaws do not require it, only the 5 physical locations. So must it be also posted on the website to be legal?
Under the Brown Act, the Brown Act requires 1 physical posting. So the Department of Neighborhood Empowerment or DUN may have additional, the 5 places, but that's not a Brown Act violation. That may be a violation of DUN's rules or of your bylaws, but it's not a Brown Act violation.
Can I respond to that? Again, that's a common issue, a common question. Yeah, under the physical, and the agreement to post at the 5 physical locations is an agreement that the neighborhood council made once they became certified. It's part of the application to become certified, and then it would be also part of the plan, correct, Darren? But it's definitely part of the application. There's an addendum to identify 5 physical posting locations, of which 1 has to remain accessible 24 hours a day. That anyone can get up at 2 a.m. in the morning and go see the agenda visible. That's behind closed doors. Now, under a recent Board of Neighborhood Commissioners decision, board meetings of the board have to be definitely use the 5 physical locations, along with sending it to our department so that we can post it on the early notification system, the ENS. Number 2, if you have a website, post it on your website.
Is that required?
Okay.
Or
Yes, for board meetings.
advised? Okay.
For board meetings. And then also, along with that, if you utilize a email database, then you also distribute it via your email database. So basically, those are 4 manners in which board meetings have to be posted now under that ruling by the Board of Neighborhood Commissioners. That applies to regular meetings and special meetings of the board.
I heard 3.
Okay, so 5 physical posting locations, distribution via ENS, the early notification system, through our department. So you send it to ncsupport@lacity.org. Number 2, your website, number 3, your website, and number 4, your email database, if you maintain one. Okay, again, for both your regular and special board meetings. Your committee meetings are required to post at the 5 physical locations. Okay, and if you have a website, you definitely post it and distribute it, but under the commission decision applies to the board meetings.
Thank you.
And to go a little further with that, the difference is Brown Act compliance, which has criminal penalties, versus being non-compliant with Dunn's rules, your agreements, and the Board of Commissioners. So you may not go to jail for violating what Melvin has said, but if you don't do the bare minimum that's required by the Brown Act, you could, if certain findings are made.
Well,
Yes.
just a question about posting it. So the Brown Act does not require agendas to be posted to a website. Is that correct?
Aaron?
The Brown Act does not require neighborhood council agendas to be posted to a website. Yes.
Okay. So in a follow-up question, if we need to post to at least one 24-hour physical location, sometimes it's challenging when you've got a large agenda to find enough space on a public, some of our bulletin boards that are in a window, or some of the businesses don't want us plastering a window. Can we take that and tape it to a post outside? I mean, knowing that that's not going to last very long. I mean, we're looking for some permanence, but if we've got a requirement to post an accessible agenda, can we post one outside to a pole and meet the requirement of 24 accessibility of an agenda with that piece?
Well, my understanding is that post is not an allowable place to put any announcements, period.
Well, I'm not talking about nailing it to a telephone pole, but to an outside, I mean, the outside of a wall at a designated posting location, somewhere that's outside in the elements, where somebody can come along and take it down 5 minutes after you put it up.
Yeah, as long as yeah, exactly. So as long as it's identified, I mean, a minimum of 5. You can have as many more as you want, but a minimum of 5, and it's one of those, it's accessible to the public, 24 hours a day, then yeah, that would meet. Right, exactly. I mean, and we have no way of guaranteeing that it'll remain there.
There's not a maintenance requirement, like we have to post it and make sure that it's there the next day.
It's a posting requirement.
No.
It's a posting requirement. And like Alois said earlier, unfortunately, with some NCs, we do get to the point where we advise them, if you have a cell phone with you with a camera feature, go ahead and take a picture, because we've had those situations with some neighborhood councils, and they'll come to the meeting and announce that, yes, here are the pictures where we posted it. And so, yes.
I got one question for why 5? How did you come to that number 5?
That's just the number they came up
I'm
with.
asking him.
He's not the policymaker.
Right.
So that's not a productive question for
I don't know
him.
behind the scenes.
Jim Hahn's lucky number.
Okay, so for special meetings, you have the requirements of posting, but you only have to post 24 hours ahead of the meeting, rather than the 72 hours.
Say that again?
For a special meeting,
Okay.
the required posting time for the agenda is 24 hours before the meeting, not 72 hours before the meeting. When you have a special meeting, those are usually meetings that deal with a certain subject that is separate and apart from what you would deal with at a regular meeting. And you can only discuss those issues that are on that agenda. Emergency meetings do not require Brown Act postings. But emergency meetings are going to be something that your neighborhood council will probably never encounter. So to be safe and to be in compliance with the Brown Act, you should always try to post at least 72 hours ahead of time. You should post in the required locations and have at least one of those be accessible 24 hours. You should make sure that your agendas are complete and provide the public with enough information to be able to make an informed decision on whether they want to come or not and what is at stake if they don't come. The public has certain rights when they come to neighborhood council meetings. They have a right to listen and hear. They have a right for you not to go behind closed doors and discuss issues that are pertinent to the community. The public has a right to address the board regarding any action or any agenda item before the board takes action. So that doesn't mean you talk about everything, 1, 2, 3, 4 agenda issues, and then give public the right to comment. You have to give them the opportunity to comment on it before you take any action. So the best practice for that is when you have an item that's up on the agenda for discussion, then after the board has discussed it, then take public comment on that issue. Separate from that, the public has the right to make public comment on anything that may be the subject matter